Now, yes, Lordship, in compliance with the Lordship's direction, I have already filed an affidavit by stating that at the time of inspection, no new construction was made.
No. Let us see.
Yes, Lordship kindly takes up my affidavit. Respondent number 5. Respondent number 5.
Ranjan Das.
Ranjan Das. Yes.
He is the executive
engineer. Right. Lordship. Yes. Lordship kindly takes up page 4, paragraph 4.
Suspend him now.
No, the matter,
we will suspend him now.
But the matter is being processed.
We will suspend him now for this affidavit. Trying to hoodwink the court.
No, Lordship kindly sees.
No, please answer the question,
My
Mr.
lord.
Counsel. You are representing a statutory body.
My lord.
Okay. He is a paid employee of the corporation. He has got a date of retirement also. Right and now we will suspend him. Right and now we will suspend him for his irresponsible affidavit which he has filed before this court. It's a clear attempt to hoodwink the court. If he thinks he is above law, we will show him what is the law.
No, that is.
He is not going to go home today. He will go to the correctional home.
No, I
from the office, which he is in SN Banerjee Road, he will go to the correctional home, not to his home. You never file such affidavit. You are a counsel representing a statutory body. You have to vet the affidavit before it is filed. Here is a case, admitted case of G+2 approval granted, 3, 4, 5 unauthorized. So what you should do? You should have inspected it.
No, we have.
Only one at a time. Okay. You should have inspected it. 3, 4 and 5 floors cannot come within a day. It is a lane of 6 feet. Where did they dump the construction material? So your fellows, your inspectors, your junior engineers have connived with the private respondent in indirectly assisting him to put up this construction. Maybe it is a 100-year-old construction. You have no power of regularization. Even such power was there under various statutes framed by various state governments that have been struck down. Amnesty scheme was brought by various state governments that were all struck down. In one of the judgments, I think in this compilation it is there. It is called Consumer Action Group. Consumer Action Group. That matter arose from my home state, where 3 government orders were passed, where sanction was obtained for ground plus 3 floors, and construction was made for ground plus 11 floors. Only once the Honorable Supreme Court granted a one-time exemption. The state government took advantage of that, and every 2 years they started issuing government orders, saying that all right, he comes under innocent builder category who has put up 12 floors. Therefore, you pay at the rate of so and so rupees per square feet. As a regularization fee, we will regularize. All those government orders have been struck down. So therefore, what he should have done is, he should have filed a plain affidavit saying that, sir, I went and inspected. As per my office record, the approval is for G+2, but existing so many floors are there. And leave it at that. You have issued a notice under section 400. What is the penalty for 400? 300 rupees fine.
No.
You have not done anything. So therefore, can we not accept the submission of the petitioner's counsel?
No, I'll say
that your engineers are colluding and conniving with the private respondent.
No, may I not make my submission? But
we are going to direct immediate action subject to what the private respondent will say. You see, the thing is, cosmetic demolition.
No, that will not do. That will
cosmetic.
No, that will not do.
So your engineers don't think they can outsmart everybody.
No, but nowadays
probably they can outsmart you, not the court.
No, may I just say this? But on earlier occasion,
senior has come. Mr. Ghosh has come. So when such an affidavit is brought to you, before it is vetted and signed, you should say no. You place facts, sir. Statutory authority should place facts. You can never support this man, assuming he has put up construction unauthorized. Take action against him.
Of course, sir.
The entire lane. Take action against everybody. Why are you afraid? Court will protect you.
My lord. Well, I know, my lord, this bench, my lord, always protecting us. Yes. Earlier, but in many cases, the lordship also they get assistance.
This Ranjan Das affidavit is very.
Well, let me look into that. But I could not go through the lordship and takes it up, and of course, my lord, the lordship, my lord, direction and whatever.
Today, the matter is going to end. What is the private respondent stand?
First of all, my lord,
very influential man, your client.
My lord, that person died. Person who.
But the nemesis will continue, sir.
My lord,
sir, the person who illegally, inherited the estate, inherits not the estate. Along with the illegality, he inherits.
That is the widow of the earlier landlord. Private respondent number.
We created a first case, my lord.
Case of rape against your client. Widow of the original owner.
Widow of the original landlord. Now, whatever construction was done was around 20 years ago. I do not have any knowledge about how the construction was made or whether it was made within the sanction plan or
no, it is not. That's an admitted position.
If that's so, my lord, whatever citations my learned senior friend has cited, none arose from a public interest litigation. I am on a very simple point. Well, kindly, if well, the petitioners well, had filed a writ petition. Well, WPA 15530 of 2024, same cause of action. They withdraw it, seeking liberty to file the same on a same fresh cause of action. Now, what they do, Malad, they do not approach that court. They come direct to this court for filing a public interest litigation. Now, whatever citations that has been followed by, whatever that relied upon my senior friend, arises from an orders that was passed not from a public interest litigation. All those citations, all those states, and they do not have a separate tribunal. Over here, the KMC tribunal has established. My lord, we have now the bench are operational. After my lord has passed orders, my lord, the judges have been appointed, the bench is now operational. Good, bad, indifferent, let KMC pass and demolition order. Let us contents. There are around 50 families in that 5-storied building. He ought to have made them parties.
Who indicted them?
I don't know. My husband, my late husband.
Then walk out. You walk out. Ask the client to walk out.
I may walk out of the premises. What about the 50 others?
He will deal with that 50 families. KMC will deal. Police will deal.
What about that? Is the only point I was thinking.
Sir, we can't do anything. Even assuming you are questioning the bona fides of the writ petitioner, the court can always discharge the writ petitioner
Yes, my lord.
and entertain the matter. Here is a patent illegality. Assuming there is a fire accident, admittedly, in a gully which is about 6 feet wide, nothing can go inside. Even an ambulance cannot go inside. At best, 2 or 3 two-wheelers can be taken inside. So in that, if you put up such a construction, whom are you putting in peril? Probably, all right, 53 families will get charred to death. The neighbors also will get charred to death. That's the problem, no? It is not your building alone. If your building tilts, your building catches fire, what about the neighbors? They are in a Tika land with a tiled property. That will be the first, they will be the first victim. You are in a concrete construction. Sir, you proceed.
Well, Your Lordship, all that I'm submitting to Your Lordship, I appreciate that is a total construction is unauthorized. Passes are in occupation. Your Lordship directs the police to vacate from first floor of the top floor and on the floor to floor. Then we may start the construction of the demolition of the structure with the assistance of
4, 5.
My lord.
They will be evicted.
My lord.
They will be given an opportunity to vacate. If they don't vacate within a time frame, then the police will assist. Police will take action. Where is Mr. Who appears for the state? He was appearing online.
Additional government pleader.
No, he appeared just now.
No. Yeah, only.
Mr. Biswarup was appearing.
Only. Mr. Biswarup only.
He was in. Where is he?
He was online. He was online. He is online.
Online.
He appeared. This public interest writ petition has been filed, highlighting a menace which is plaguing the larger part of Kolkata and several parts of the state of West Bengal, wherein illegal and unauthorized constructions have been put up, and the authorities have failed to take any action. At the very outset, we shall deal with the preliminary objection raised by the private respondent, the present owner of the building, with regard to the locus standi of the petitioner to file this writ petition. It is submitted by the learned advocate for the private respondent that the writ petitioner had earlier approached the learned single bench of this court by way of a writ petition for the self-same relief. Somebody called Mr. Biswarup Basu Malik.
Only
Self-relief, which was withdrawn with liberty to file a fresh writ petition, but without approaching the concerned court, this public interest writ petition has been filed. In our considered view, this objection is wholly untenable, since the petitioner has not only exposed the cause, his cause, the petitioner has exposed the cause of all the people who are residing in that particular lane, which is stated to be only 6 feet in width. Therefore, we reject the preliminary objection raised by the learned counsel for the private respondent as regards the locus standi of the petitioner to maintain the writ petition. The next submission of the learned advocate for the private respondent is that if as and when the Kolkata Municipal Corporation within bracket KMC passes an order of demolition, it will be well open to the private respondent to approach the building tribunal, which has been constituted under the provisions of the Kolkata Municipal Corporation Act, and seek appropriate relief. Such submission cannot be accepted in the instant case because the matter concerns the safety and security of all the people who are residing in in the said area, which is a narrow lane measuring about 6 feet in width. Therefore, the private respondent who has admittedly put up illegal constructions or with the illegal construction of third, fourth and fifth floor in the premises without obtaining any building plan approval has absolutely no ground to plead for any equity being exercised in their favor. If the private respondent pleads for equity to be exercised in their favor, the private respondent or her husband, who was the predecessor in title, should have acted in equity. And since it has not been done so, the question of the private respondent seeking umbrage under the various provisions of the Act in order to escape the rigor of law cannot be accepted. Therefore, such contention raised on behalf of the private respondent also stands rejected. A report in the form of an affidavit has been filed by the executive engineer within bracket B of Borough Roman 9 KMC, Mr. Ranjan Das, dated 7th November 2024. To say the least, the averments in the affidavit shows that the officer does not want to place full facts before this court. And we may be justified in accepting the stand of the petitioner that the officer is colluding with the private respondent and trying to protect and shield them from any action against the unauthorized construction. The affidavit filed by an officer working under a statutory body should be clear and unambiguous and state the exact factual position. Any other averment which may give a color to support a particular party should be fully avoided, should not find place in such affidavit. However, on going through paragraph 4 of the affidavit sworn to by Mr. Ranjan Das shows, gives a color as if the said authority is attempting to protect the private respondent who has admittedly private respondent's property, which is of which third, fourth, and fifth floor are unauthorized. Several judgments have been placed by the learned advocate appearing for the writ petitioner in support of his contention as to how the cases relating to unauthorized constructions have to be dealt with. We may refer to a few of the said decisions.
পুরো খিদিরপুর ফাঁকা হয়ে যাবে তো একবার পুরো মুভিপুর তো ফাঁকা হয়ে যাবে
The Honorable Supreme Court in Dr. G.N. Pajuria and others versus Delhi Development Authority and others 1995 5 SCC 762 pointed out that the authority concerned misused the power and allotted the plot earmarked for a park for a nursery school, which was condemned, and the order for cancellation of the allotment, besides recommending penal action against the authority concerned, was made. In MI Builders Private Limited versus Radhesham Sahu, 1999 6 SCC 464, the Honorable Supreme Court in clear terms held that there is no alternative to the construction which is unauthorized and illegal to be dismantled. In Isha Ekta Apartment Cooperative Housing Society versus Municipal Corporation of Mumbai, 2013 5 SCC 2013 3 SCC within bracket civil 89, the Honorable Supreme Court observed that the courts are expected to refrain from exercising equitable jurisdiction for regularization of illegal and unauthorized construction. In Supertech Limited versus Emerald Court Owner Resident Welfare Association others, 2021 10 SCC page 1, the Honorable Supreme Court held that illegal constructions have to be dealt with strictly to ensure compliance with the rule of law. In Kerala State Coastal Zone Management Authority versus Maradu Municipality, 2021 16 SCC 822, the Honorable Supreme Court reiterated that illegal and unauthorized constructions put up with brazen immunity, BRAZE, cannot be permitted to remain. In state of Haryana versus Satpal, 2023 6 SCC 643, the Honorable Supreme Court held that the High Court committed a very serious error in directing to legalize the unauthorized occupation and possession made by the original writ petitioners on payment of market price, and the same was quashed. The aforementioned decisions were taken note of by the Honorable Supreme Court in a recent decision in the case of Rajendra Kumar Rajchetia and others versus UP Evas Imam Vikas Parishad and others, civil appeal number 14604 of 2024, dated 17th December 2024. Some judgments. It is starting from page 34 of this compilation. You see, it's called index supplement. 34. Take it from. So the Honorable Supreme Court in the set judgment affirmed the order passed by the High Court and issued the following directions.
Para 4A and 6 I only bill কি করে মেনটেন I only bill মেনটেন দেবে না
Just the sum and substance of all the aforementioned decision is that there can be no concession granted to a person who has put up illegal and unauthorized construction, and there is no question of exercising any sympathy for such persons, nor the persons who were put in possession of the premises which have been illegally constructed. Having held so, the only conclusion which we can arrive at in the case on hand is to direct demolition of the unauthorized construction, which is the 3rd, 4th and 5th floor in the building in question. Very interestingly, the learned advocate for the petitioner would vehemently contend that the officer in charge, Vatunge Police Station, Kolkata, 7,23,000, is colluding with the private respondent. And this is evident from the fact that a false FIR has been registered against the writ petitioner for the reason that he has approached this court and filed this public interest litigation. In this regard, a specific government has been made by the writ petitioner in their supplementary affidavit. And a case has been registered in FIR number 137 of 2024 on 27/6/2024 against the of which in this regard,
What the CRR file was?
in this regard, legal notice was issued to the officer in charge, Watganj Police Station, dated 8/7/2024, wherein it has been stated that stated about the circumstances under which the FIR which has been registered is illegal. Apart from that, they have stated that they will claim a compensation of ₹1 crore against the police authorities for committing such illegality. And we are informed that a writ petition in this regard has also been filed by the petitioner. The petitioner challenged the FIR number 137 of 2024 before this court in CRR number 3044 of 2024. And the case has been entertained, and there is a direction that no coercive steps be taken against the petitioners in connection with the said case. This order is said to be in force as on date. We may not be justified in making any observation as regards the FIR which is registered against the petitioner, but we prima facie feel that the FIR has been registered so as to silence the writ petition, not to proceed with the case against the private respondent. However, we refrain from making any further observations in this regard, as the Honorable Court is seized of the matter in CRR number 3044 of 2024. The writ petition was date of filing 10th of July. The writ petition was filed before this court on 10th of July 2024. The matter appeared in the list on 1st of August 2024 and was adjourned to 29th August 2024. And on 29/8/2024, the appropriate authority of KMC as well as the 7th respondent police was directed to file a report in the form of the affidavit, and the matter was adjourned to 19th September 2024. Thereafter, the
What about the extinction of interim? What about the extinction of interim order which was granted
My lord,
on August 9, 2024? The
Excuse
interim
me,
order that
there
was
were-
granted
already extended, and 11th April is the date of fixed, my lord.
11th
And
April.
it was extended till end of April and fixed the matter on 11th.
subsequently, the matter was heard on 19/9/2024, 11/11/2024, and 7/11/2024, wherein directions were issued.
My lord, kindly see.
However, no, after all the directions which have been issued, the administrative officer within bracket buildings, Kolkata KMC, issued a notice to the writ petitioner to appear for a hearing on 17/12/2024 in respect of the premises of the private respondent. In our view, the said notice is clearly an afterthought and probably to give an impression to this court that the authorities of KMC are taking action. Therefore, we hold the notice issued by KMC to the petitioner dated 10/12/2024 is a clear attempt to hoodwink make the present proceedings ineffective. Therefore, the step taken in this regard by the said officer, namely administrative officer, building department KMC, is deprecated. All right. In the light of the above conclusion, we issue the following direction. The
Kindly direct the DC.
following direction, considering the fact that taking note of the submission of the learned advocate for the private respondent, that there are about 53 families who are in occupation of the premises. The said persons who have been inducted either by the private respondent or by her late husband have no right to remain in the said property, since it has been confirmed that the constructions of third, fourth and fifth floor in the building is wholly unauthorized. Therefore, we direct the Commissioner of Police, Kolkata, to issue appropriate orders so as to enable the Deputy Commissioner of Police, Port Division number 1, to deploy adequate police force to remove the occupants of the three unauthorized floors. The question would arise as to whether notice has to be issued to them. And admittedly, the construction being illegal, the occupants cannot claim any equity. Apart from that, the building has been constructed in a lane with a width of 6 feet. And it is not only not only the occupants of the illegally constructed 3 floor are at peril, but the other residents in the lane, which would include the petitioners also, are at peril. Therefore, the police authorities are directed to give notice to all the occupants to vacate the premises by themselves by 30th of April 2025. If any of them still continue to remain in occupation, they shall be evicted by deployment of adequate police force, and such process shall be completed not later than 16th of May 2025. After the 3 floors are vacated, the KMC shall initiate demolition proceedings, for which also the police authority shall deploy adequate police force, and such demolition shall be completed and a report be filed before this court, supported by photographs.
Videography, my lord.
For photographs on 19th of June 2025. During the process of demolition, during the process of vacating the occupants of the building, as well as during the process of demolition, the entire events shall be videographed, and such cost shall be borne by the Kolkata Municipal Corporation. List the matter on 19th June.
But I will communicate his lordship's order, my lord, to the Commissioner of Police, lord.
Before list the search. Needless to state that this writ petition being a public interest litigation, it goes without saying that it is not only the construction which has been put up by the private respondent which is to be dealt with, but the KMC authority should also cause inspection of all neighboring properties. And if any violation is found, the above directions will apply mutandis to such constructions as well. Of course, action be taken after issuing notice to the concerned notice to the owner/occupant of those properties. List the matter on so and so. Mr. Basu Malik, we have not made any observations against the police officer.
No, my lord, I will communicate. I have seen that.
No, sir, this is very wrong, sir. Sir,
my lord. When it's a counter case in that area, lordship, what I will say, I will not to say anything, but it's better not to say anything.
They have given so much of particulars regarding mobile tower location. It's very, very doubtful whether these fellows, the complainants, were present in the police station.
Lordship. I will talk with the office of the commissioner, and I will ensure that the order should be complied with, my lord.
One time you take stringent action, then automatically things will fall in place.
Lordship.
It will be a deterrent for the persons who want to do something like that in future. You go slow, then everything will be taken for granted.